Hi, I'm Steve Hansen with Hansen IP Law. Today I want to talk to you about two things you should do before you tell anybody about your invention. A lot of clients come to me and they have an idea for a new product, but they want to talk to somebody about it. Like perhaps they want to talk to investors who may help them get the resources to manufacture the product. Or maybe they want to talk to a potential customer who may be interested in entering into an agreement to buy the product. But they're worried because if they go in and talk to these people, there's always a risk that the people will take the idea and just use it for themselves, or run to the patent office and file their own patent application and block my client from using their own idea, which is obviously not a situation that anybody wants to get into. So when you are going to disclose your invention to a third party, the first thing you should do is file your own patent application first. If you could file a non-provisional application, of course, go ahead and do that. If you're limited on resources, or limited on time, then, you could file a provisional patent application, especially if you don't have a lawyer or you can't afford one at this point in the process. You can file your own provisional patent application electronically through the U.S. Patent and Trademark Office. I can't really teach you how to file or write a patent application here, but what I can tell you is that you're basically going to want to describe how to make and use the invention in enough detail so that somebody skilled in the art could make and use it. You're going to want to describe examples of the invention, specific examples or implementations of it. We call those embodiments. But to put in the application as much detail as you're capable of putting in there, and then get it on file. Now, a patent application won't give you the right to sue anybody or go to court if they misuse the information that you provided to them. What filing the patent application does is it gives you priority in the patent office so that you can stop somebody else from filing a second patent application based on your information. The second thing you want to do is have the other party sign a non-disclosure agreement, or NDA. What an NDA does is it requires the party that you're providing your information to use it only for purposes of evaluating whatever deal you're contemplating doing with them. They're not allowed to make their own products based on the information. They're not allowed to go file their own patent applications based on the information. And they're not allowed to disclose it to third parties. And what an NDA does, it gives you a contractual right that you actually can go to court with and can sue on if this other party misuses the information that you provided to them. So the patent application gives you a property right once it issues as a patent, and the NDA gives you a contractual right while you're waiting for the patent to issue so that you can stop somebody from misusing your information. Now, not all companies will sign NDAs. If you're dealing with a big organization, they may have a policy against signing NDAs because they are afraid of getting into litigation. And they may have the leverage to do that. They may not need the deal you want to strike with them as much as you need that deal. So you'll have to make the decision about whether it's worth the risk to you that they might misuse your information so that you would go forward. If it's not worth the risk, then you should go elsewhere. But those are the two things you absolutely want to do before you tell anybody about your invention. File a patent application and have them sign an NDA. Okay? Until next time, I'm Steve Hansen.